Okay, ladies and gentlemen, ladies and gents, doing this video is especially going out to a young man who's dealing with a corrupt system. That corrupt system happens to be here in California, Sacramento to be exact. We have a court that's threatening the individual that they're going to revoke his bail if he don't start talking to the attorney. That's right, they told him that he is under orders to talk to the attorney. You know, the attorney has actually taken conversations he's had with the attorney and put on the record of the court. The attorney actually told the court that he failed to meet with him over a month ago. The court listening to the attorney saying that he failed to meet with him, although he was there, his father was there with him. The attorney just said he didn't do it. They arrested him, revoked his bail, put him in jail, because the attorney said they failed to meet. Would not listen to any other counter evidence. The attorney testified against his client. Ladies and gentlemen, oh, this is high five. I can't wait another minute. Ladies and gentlemen, when this song first came out, in love with this song, okay? Oh, look at that. I gotta make sure this thing ain't starting over. I had my microphone on when the video started. When I did it the last time, the video kept starting over. So, let's do this. The right to remain silent. Don't mean to make you cry. We haven't got much time. It says, please enter URL. I ain't entering no URL copy. I ain't entering no stupid URL. Oh, that's because of all that up there. It was typing up all that when I was talking. I didn't know. Okay. They said that he does not have the right to remain silent, ladies and gentlemen. The right covers a number of issues centered on the right of the accused or the defendant to refuse to comment or provide answers when questioned, either prior or during legal proceedings in a court of law. This can be a right to avoid self-incrimination or a right to remain silent when questioned. If the attorney wants to question him about certain events, he's going to say, no. But he's asking me what to do. What should he do? Well, see, you do it my way, you're going to be arrested. But if you don't do it my way, you let them know that they got a way out. My way gets you court issues taken care of on appeal. Hold on. Right to remain silent. Pay attention. I tell people they need to just look at the law. Suspect's silence during interrogation does not invoke his right to remain silent under Miranda. Voluntarily or knowingly responding to police interrogation after remaining silent constitutes a waiver of the right to remain silent, provided that a Miranda warning was given and the suspect understood it. Okay, once you've been given your Miranda rights, and everybody's been given a Miranda right, once they give up that Miranda right by talking, they waive that right. They have to exercise that right. Okay? And since anything a person says can be used against them in a court of law, pay attention. Since anything they say can be used against them in a court of law, then they have the right to remain silent throughout the entire proceedings. Okay? Salinas versus Texas, right to remain silent, Supreme Court, right to remain silent. See, it says the Supreme Court held that you remain silent at your peril. Wait a minute, at your peril? Oh no, you have the right to remain silent. It's not at your peril because, ladies and gentlemen, I put it to the test. I told the court I wasn't saying another word. I told y'all what happened when I did it. I did it twice. Told the first court I wasn't saying another word, and she, you know, you could see the fear in her face. Federal judge didn't know what to do. Did not know what to do. Now watch this. Attorney testifying against the client. Stop listening. I'm not, can a lawyer testify against me? This is what a person, testimony does not equate to spilling secrets. Really? So they got case law that allows an attorney to testify. Now, we're not talking about a lawyer that has been subpoenaed, but see, ladies and gentlemen, an attorney cannot be subpoenaed to testify against a client. That's attorney-client privilege. Everybody knows that. If it happens, it either means that you are now adversaries on opposite sides of a case, or that the lawyer has been subpoenaed or is obligated to testify. Regardless, a lawyer has an ethical obligation to maintain client confidence to the extent possible, which means the testimony does not equate to spilling secrets. You see how they turn it around? Okay, judges are more likely, however, to disqualify a lawyer that's called to testify against the client if there is a likelihood that the case will go to trial before the problem of having a lawyer as both witness and advocate in the same proceeding. And we're going to call the lawyer to testify. In this case, the lawyer is going to be called as a witness. I'm doing this for the individual so that he can do his own research. Okay? When is it ethical for a lawyer to testify against his client? Can a lawyer testify against me? It's what that first thing said. Attorney as a witness for his client. There you go. That's what you want. Okay? We don't want an attorney testifying against... Look, can an ex-attorney testify against his client? Look, ladies and gentlemen, her former attorney cannot testify in a civil action as you described. However, look, they're saying, oh, there's a difference between civil and criminal. No, attorney-client privilege extends to both civil and criminal. There is no distinction between the two. It's just they like to play around with the statute. Okay? So let's open this up, y'all. New edition. Or no, this is Better the Vote. Over and over and over and over and over again. Don't hurt the one you love. No. Girl, you see that I apologize. So tell me what to do to get through to you. Oh. Girl, it's not the same, 'cause I know I was to blame. It wants me to give it some access, so I gave it the access so it'll leave me alone. I'm just trying to finish these because I started them, and it says no, access is denied. It says it ain't letting me download them. So if I can't download them, wait, these are my documents. Interesting. I'll have to re-download them. Okay, ladies and gentlemen, we're gonna open up this. Open, okay. And attorney as a witness for his client. Okay. We're gonna have the attorney because the individual is bringing up the defense of the denial of due process. He's gonna still hang with the denial of due process because remember, no one can be held to answer for a crime without due process of law. You all know it. It's called the Fifth Amendment. Okay? It is a very good defense when it is argued properly. Not everybody can do it because the courts will break their neck. The Fifth Amendment of the United States Constitution. Text. Stop listening. No person shall be held to answer for a capital or otherwise infamous crime unless, pay attention, let's go there because I don't want Wikipedia because Wikipedia doesn't give me what I need. I don't want Constitution either, but we're going to go to the usconstitution.net. We can go there because it's just a website that just has the Constitution. They don't add nothing else. If they do add other stuff, it's just gonna be other stuff that is reference work and stuff like that. But we don't really care about that stuff, don't we? We don't. We do. What we. Yeah. this, Rolls Royce? They want to just get next to something? Okay, it says, nor shall any person be subject to the same offense twice, nor shall be compelled in any criminal case to be a witness against himself. Okay, he has the right to remain silent against self-incrimination. They want him to testify. Since everything he tells to the attorney goes back and tells to the court, he has the right to protect himself. Thank you for giving me a cause of action. And he puts it in writing, and he lets the court know that it's a violation of his due process right for that attorney to go back to the court and to tell them of their conversation. If he had a problem with something, he should have expressed it. But to do it in court, I don't think so. So what's going to happen is eventually he will let the attorney know and the court know that he's recorded every phone call. But they'll say, well, you were supposed to give him notice that you were recording his phone calls. I'm sorry, Your Honor. He came in the court and he showed the court my conversation and told the court about my conversation. So he revealed to the court my conversation, which means he recorded my conversation and placed that recorded conversation in one fashion or another on the record. So if he's recording my conversation, I have the right to record his conversation. You just got to be able to argue the point. But everybody's not like you. Everybody doesn't have to be like me, ladies and gentlemen. Let me see if I can do this. I finished the document. We're going to do this. So I got a couple of minutes before we have our meeting. I want to show you guys something. And we're going to do the right to remain silent. And we're going to talk about the other information. I think I did it. Let me see. Come on. Okay, we're going to go to the bottom. Not that bottom. The bottom. The courts, because people have been doing bankruptcies and they've been doing it for the non-individual, the courts have been giving them a hard time. Okay, ladies and gentlemen, that bothers me that they've been giving people a hard time. Since doing it as a non-individual is permissible by the actual statute, permissible by the rules of the court. So this is what I wrote for two women who are said to go into court to argue the point. Got to send this to another young lady today. A young lady I just got off the phone with, who the courts have said that because she fainted in court, that she must have a psychological problem. She went to the hospital, and the hospital said it was directly related to diabetes, but the court said it must be a psychological problem or associated with psychological problems, which means there's a problem. She asked the court if it believed in God because of scripture, because of other people using scripture in the court. Did the court believe in God? And the court went all the way around the corner, then took a flight to France, then took a train to Istanbul, then got off, took a boat to China, and then decided it was going to take a SpaceX flight in China. SpaceX is not even in China. And it was going to go all the way to Uranus, somebody else's anus, and then it was going to come back and go back the same route it went and still not answer the question. So the court suggests that because she mentioned God and because she spoke of certain things being a sin against her father, being God, the court says she must have mental instability. So I suggested to her, just ask the court, then the prosecution must have mental instability as well. Before we do that, hold on, ladies and gentlemen, that's Orange Juice Jones again. We played him earlier, we're gonna let him play now. Let me show y'all something. Wake up. The motto of the Department of Justice, question mark. Stop listening. Ladies and gentlemen, what's the motto of the Department of Justice? Can anybody tell me? Quod pro domina justia equita. Quod pro domina justia equita? Who prosecutes on behalf of Lady Justice, Diana? The goddess Diana. You see, Lady Justice, watch this. Hold on. We ain't gonna go down. We don't need to go down. Downtown, we don't need to go there. Watch this. Google search. Lady Justice. Lady Justice is an allegorical personification of a moral force of the justice system. Lady Justice originated from the personification of justice in ancient Rome art known as Greek goddess. You see, Greek goddesses, and she was a dyke. Okay, but it's the Greek goddesses. See, this is Wikipedia, and that is not what we were doing. That's the argument the courts will get you. Ladies and gentlemen, I want Lady Justice for who she really is. Diana. Okay? These are all the images of Lady Justice, and you see why she's holding the scales? It's not the balance of justice. It has nothing to do with that. It's all symbolism. Okay? But notice that she is garbed in a Greco-Roman toga. Okay? The reason why Lady Diana, okay, they talk about her blindfold, they only added that junk later. She was not blindfolded at first, okay? She's a slut. I mean a hoe. I mean a prostitute. You know, she's a female pimp. Okay? That's right. Now close your mouth. Now watch this. We're gonna do Lady Justice D-I-A. See if it's gonna fit A-N. Hey, look, it says Lady Justice Diana Ross. Oh, please, that ain't what we're doing. The Lady Justice Diana on Google. See, they know who she is. Okay? They know that she be Diana. Okay? Lady Justice, Lady Justice, Lady Justice, Lady Justice. Okay? Let's see. Hold on. I beat you, I bought you, that's right, everything, that's right, everything. Don't be fly with me. No, don't go look in that closet because you ain't got nothing in there. Everything you came here was packed up to wait for you in the guest room. Okay. Oh, Wonder Woman, ladies and gentlemen. Princess Diana. Okay, This with the juice. You know, I gave you silk suits, Gucci handbags, blue diamonds. I gave you things that couldn't even pronounce. Look, Lady Justice, Princess Diana. It only just Princess Diana, but it knows exactly what I mean by justice. That's why she's a member of the Justice League of America. Somebody like me one of these days. Until then, you know what you gotta do? You gotta get on out of here with that calico cool wear, hush puppy, crumb wear, shoe cupcake. I saw you. Because you dismissed. You dismissed. That's right, silly rabbit. Don't you know tricks to make the kids? You without me, it's like cornflake off milk. This is my world. You just a squirrel trying to get a nut. Get on out of here. Don't touch that coat. Okay, what I need is let's see. The goddess Diana in the Bible. I know it's in the book of Acts. I've already shown you guys that. See, Latin, Diana was the goddess of the hunt, the moon, the nature in Rome mythology, associated with wild animals and woodlands, and having the power to talk and control animals. She is equated with the Greek goddess Artemis, though she had an independent origin in Italy. Okay, that's because they trade gods, ladies and gentlemen. This has been the case for quite some time. Diana of the Ephesians, or Ephesus. Okay, and then it says Artemis definition meaning Bible dictionary. Okay, this is truth. They didn't hang around very long, did they? I like truth, y'all. I even like the name Truth. I mean, it just was perfect for the time. 80s, truth, you know, movement, stumping, the yard, and all of that stuff came out at the right time. Deity, isn't it? Origins, the mother goddess of the earth, whose seat of worship is in the temple of Ephesus, the book of Ephesians, Ephesus. Okay, the Ephesians. The capital of the Roman province of Asia. Diana is but a Latinized form of the Greek word Artemis, Yet Artemis of Ephesus should not be confused with the Greek goddess of that same name. Okay? She may, however, be identified as, I don't know. Okay? This is the goddess that they worship. The goddess of justice. Now, if you notice, to show you the history of this, the Romans didn't invent her. The history goes back to quite some time. This is where it is in Scripture, ladies and gentlemen. Okay, Acts 19:35. Okay. The tradition says Diana was born in a wood near Ephesus, and her temple was built, and her image of wood, possibly ebony, fell from the sky. She was born in the woods. I told you she was a woman. Okay, anyway. Well, when there's a woman born in the woods, people? Okay? Okay. All right, you know what I'm saying. Read your own mind. Okay, getting back to that. Ladies and gentlemen, we got off into this because they wanted to question somebody's belief. You turn it and put it right back on them. Say, why is it that the motto of the Department of Justice is he who serves the God is justice? The false God, a fake God, not symbolism, not an image, a God. It says the goddess justice. That's their motto. So if they serve the goddess justice, when I ask this court, does it believe in God? I'm asking for a reason. I'm asking to check the competency of this body, not my own competency. You people believe in pagan gods. That's not how this country was founded. That's not the ideas of the founding fathers, you ignorant mother. Okay, that's where we're going with this. I hereby notify the court that I'm not an attorney, but I received this presentment from someone who is competent enough to understand the complexities of law. For instance, the clerk of the court is introducing to the appeals court evidence, or to this court evidence. You don't have to say appeals, but these work for two people who had appeals going on. If it's going to be for you, you say for this court evidence that I'm a subject to. I never consented to being a juristic person, a legal person, or a legal construct. Let's do this. Okay, need to get the correct word, sorry. Wait a minute, I know I got that word right. Hold on, gotta go up top. Whee! Did you go too far? I think he went too far. He didn't go too far, he's right here where he should be. I think he's there, my dear lad, I think he's there. Oh, it's I-C-A-L. I did it with the T, so that's why it's wrong. Okay. Be a separation between myself and a non-individual. As expressed above, I am a physical living person. The defendant, debtor, legal entity, captioned person is not a living person. Okay? You don't have to explain. They want to take that and spin it around, it's okay. According to the court, it does not understand the difference between a living person and a non-living person, a natural person and a non-natural person, an individual and a non-individual. And that is simply disturbing. However, ignorance of law is no excuse, and I cannot help the court's lack of knowledge or lack of understanding. I am not here to testify to the court. The court wants a cause to order to show cause. I choose to present evidence by way of testimony of the United States Congress, the General Assembly, United States Supreme Court, and the actual statute. These are the authorities that I use The court says that I do not have the right to present the legal person or to represent the legal person. Yet it, the court, can provide no case law supporting such a conclusion. The court specifically states on the record that a legal person is not perceived as a separate entity from the physical person, that there is no prohibition in statute preventing the physical person, i.e. the individual, from filing documents simultaneously with the natural person, i.e. the non-individual, or even on behalf of. This is preposterous, an absurdity, and a frivolous argument on the part of the court because it is not supported by facts and conclusions of law, and I object. The court wants to claim that someone's intent was to abuse the judicial system of the United States. This court wants to state that if a husband or wife filed separate bankruptcies, that they're construed as filing together every single time. The law doesn't recognize such a conclusion, even if it did. Such would result in an abuse of any system if they were to file together. The court has from time to time said that if a husband files bankruptcy on behalf of his legal person and a wife were to go ahead and place the documents on the record through the clerk of the court, that the wife is somehow liable for the information on the documents. That simply is another presumption and exaggeration and is meritless when it comes to facts and conclusions supported by evidence and law. The court has made quite a few presumptions, and I have gone out of my way to rebut each one of these presumptions in the above presentment, and that if the court has any further questions, I hereby state conclusively that I have responded to each of the court's contentious allegations, as well as the presumptions, and if required any further information, it needs to document that in writing and place it on the record. Ladies and gentlemen, this is the system, okay? Don't disturb this rule, okay? The clerk of the court may not offer testimony. The clerk of the court can only produce factual records, not the statements of attorneys, because the attorneys may not testify on the record. Do you guys know an attorney may not testify? Wait. Hold on. Y'all mean to tell me y'all don't know that? Wake up! Wake up. Attorneys may not testify. Question mark. Case law. Stop listening. Ladies and gentlemen, I have case law that says an attorney cannot testify. See, when an attorney gets on the stand to testify, he does so as a witness. He doesn't do so as an attorney. An attorney cannot testify on behalf of his client, okay? Such as coming into court and representing a client. It cannot happen. An attorney cannot be an attorney in a case and offer testimony. I will find that and I'll do a video on that later. Okay, but I do have the case law. I've done a video on it already, pointing out that an attorney cannot testify. Let's see, a lawyer, no. And I didn't do, see, attorney cannot testify, but it's the same one that I already put in there. So let's see. Attorneys cannot testify in court to facts if they are not competent witness of firsthand knowledge. An attorney cannot be both a witness and an adequate representative of his client. An attorney cannot testify in court to the facts if they are not competent and have first-hand knowledge. This is on script. I don't want script.
This song to all the lovers tonight.
Okay.
And I expect that might be the whole world, because everybody needs something or someone to love.
The individual who needs to see this is the part that he needs to deal with. Okay. Rule 7.1 confers professional responsibility. We just typed in the fact that an attorney cannot adequately represent his client and be a witness at the same time. Okay. And so let's do this. When I'm down broke.
But when I'm down broke, she's telling me about the things
the girl Ben's gotten, the things she ain't gotten. She wants me to go out there and get it for her. But you know, girl, I can't be in two places at one time. This is the statement I need, because, ladies and gentlemen, this is script again. If you think you're lonely now, but it only pulled up in one document. Okay. Attorneys cannot testify. Statements in counsel brief and oral argument are not facts before the court. This is what the clerk of the court wants to introduce to the appeals court. The attorney cannot sit up there and put together a motion and not be considered by the court. Okay, see, this finding of a continuing investigation which forms the foundation of the majority opinion comes from statements of counsel made during the appellate process. As we have said, of our unsworn statements, of other unsworn statements, which were not part of the record and therefore could not be considered before the trial court, by the trial court, manifestly, such statements cannot properly be considered by us in the disposition of the case. Ladies and gentlemen, this is the case law that individual that I was telling you about needs. Now, this is script. You know it ain't gonna give me everything. Okay? This is what I want. I set up for a stag. Ooh! If you think you're lonely now, I feel like I want to testify, y'all. I did not do this on purpose, y'all. The man said he feels like he want to testify, and we're talking about an attorney testifying. I told you, ain't no coincidences, see? Attorneys cannot testify. So I'm sorry, Mr. Bobby Womack, you can't testify, bruh. Sorry, bruh, you just can't do it. It's against the law. You're an attorney. Anyway, any evidence not carried with it, the seal, this is not supposed to be sealed, it's supposed to be sealed. Seal of the court, and the seal of the state, the seal of the state agency is inadmissible, as it does not carry with it the full faith and credit of the United States, and is a violation of the full faith and credit clause, and I must object to it being presented with the clerk of the court record. Ladies and gentlemen, I realize the clerk of the court sends out a notice to everybody when they're submitting the record, and they give you 14 days to object to them presenting the record on appeal. Well, why don't you guys object? They're presenting on appeal. Look, my presentments are attested to based on actual, first-hand knowledge of events and facts stated in reference to the information presented. I am presenting an endorsed original promissory note for deposit into the court for bonding purposes for staying this matter pending the outcome of my appeal. This is when you are doing an appeal with real estate. Remember, depositing into the record of the court. The endorsed note is proof of discharge of government obligation as required by statute, as given force by operation of law. My evidence qualifies as evidence as prescribed by the rules of evidence, and so I object to the court insinuating otherwise. Okay? Any decision by this court to sanction me and or to interfere with my access to the court by claiming that my filing of this presentment is somehow in violation of statute without specifically naming the statute, or specifically stating what the abuse is based on, along with the facts and conclusions of the law, is objected to on and for the actual record. I have the right to access the court, and I have the right to do so without being cross-examined by the judicial officer. I object to the judicial officer singling me out as if I have done something wrong without significantly stating what the wrong was or what the violation of law was by only acting on presumptions without rebutting the original presumption, which was my original filing. I object, and I hereby place the court as well as the judicial officer on judicial notice that it has violated my rights and is attempting to block my access to the court in violation of law. That the judicial officer has insisted on entering false and misleading evidence on a public record, which is a criminal offense, and I notify the court of this offense and its officer's attempt to violate my rights. What gives me the right to file a claim into this court? It has been stated. Evidence has been provided. The congressional intent and the authorization of statute has been placed before this body in full detail. There is no need for additional further statements by myself without the court explaining how the above does not address the issues with facts and conclusions of law and with succinct specificity, and I object to anything otherwise. Just that simple, ladies and gentlemen. That's the completed document. We did the completed video. I told you guys in the last video, I'm going to shut this down. We're going to save it. Okay? We definitely need to save this. That's why I was opening that. So I need to save this for somebody. So I'm going to open that back up. Ladies and gentlemen, what we're doing here is there are several people going through a lot. So instead of me talking to one person one-on-one, I prefer to go ahead and speak to that person on video. And then there are other people who are in certain situations. Like, for instance, there are a lot of people out there who didn't know about the Princess Diana. But there are a lot of people out there who did not know that when attorneys put in the evidence, when they put in their motions on appeal, okay, they are introducing evidence, and you must object to it. If you don't object to any and all the junk that they put on the record, as it is not supported by any facts or conclusion of law, and it is not evidence within the scope of the rules of evidence. Okay? You have the right to do that. You have the right to challenge the junk they put into the record. Okay? You have that right. Oh, you know what? This is that case. I told you attorneys couldn't testify. This is the case right here, Tinsley. Okay? This is the Tinsley case. Did the video already. That's why I said I knew I was going to find it, but look how long. Statements of counsel. Statements of counsel. It's a hurting thing, but to be known as a fool is a dying shame, or a crying shame. This is Stacy Lattisaw, y'all. I ain't even gotta look down. I know Stacy, because all of us had a crush on Stacy. Stacy, I'm just telling you like it is, okay? Every last one of us had a crush on you, and we were jealous of Johnny Gill. And we're gonna tell it to you like it is, and we ain't caring no more about no New Edition story. We just letting you know. Okay? It was just the facts, people. And I know I got a lot of you technically, you know what you're talking about. You sure know how to tell it. I know a lot of y'all are saying that. Okay? We get rid of this counsel by, we get rid of that, because that is that. I'm just getting rid of all of this because, like I said, I'm going to be sending this to somebody, and you all going to need to be typing it up and putting it together, so I might as well let it hang here, because some of you going to want this, because some of you going to be like, man, I need that. Counsel can't do this and can't do that. Man, I need that. Okay? Shoot, that information right there suits that's my situation. That's exactly what I'm going through. That's what some of you are saying. Okay? I get you. I get you. So what I'm going to do is from time to time, you're going to have me doing videos like this. To some people, they're not going to care. It's not going to be important to them. But guess what, ladies and gentlemen? To some of you, this information is extremely important because it's information you didn't know. And so it is my pleasure to provide such to you. Oh, I want the M. Ladies and gentlemen, this is what you need to know. It didn't dawn on me until the clerk of the court asked for objections within 14 days. Why does she need to know about objections? Well, now we have to object to that record because now the court can consider what the attorney is saying. And they can use that against us because he's an officer of the court. As an officer of the court, what the attorney says is taken as more weight than what we say. Y'all don't ever want that to happen. Do y'all want that to happen? This is Bobby Brown. He's singing Girlfriend. The very first time.
You the picture of love in my heart.
Of love in my heart.
You and me, girl, holding hands.
See, this is when everybody had a little bit of respect for Bobby because he was supposed to be a bad boy. Okay? All right, ladies and gentlemen, I ain't going to take you too much further than this. Oh, we're going to play Miss Shalay the next time I do a video. We definitely going to play something. That woman got something in her heart. So we're going to play Bobby Brown and Miss Shalay the next time we come around. Just wanted to do this video real quick because we needed to let all of you know that there's this issue of the right to remain silent. Like I said, when I did my right to remain silent, I literally was silent. They were furious because they didn't know what to do. Look, the attorney can't go any further. That's why they're threatening the young man. They can't go any further because they need him to participate in his own defense. Look at whenever you look at the information with regards to somebody ordering a psych eval, they have to get a psych eval to determine whether or not the defendant can participate in his own defense. If the psychologist says that the defendant is competent, pay attention. The psychologist says the defendant is competent, then that means that he can participate in his own defense, but he chooses not to. He doesn't have to participate in his own defense. Now, they could eventually come at you and say, well, because you decided to do this and you decided to do that. Don't worry about that, people. You have the right to remain silent. But so many of you think you can go into court and have a conversation. This young man thought he could go into court and have a conversation with the judge. He thinks that he knows what the judge is talking about when the judge opens and closes their mouths. He thinks that he can go and answer their questions because he thinks their questions are straightforward questions and they're not traps. Again, he thinks. And that's to his own detriment. That's why you have the right to remain silent. Anything you say can and will be used against you. Nobody pays attention. It says that it will be used against you, including by the attorney. So if it's me, I'm basically going to say, well, I'm sorry, I can't say nothing to you because the law says anything I say to you can be used against me. Sorry, this is a criminal proceeding. Anything I say from the time I'm arrested until the time the trial is over can be used against me. Sorry, can't have that. Can't have that because you've gone into court several times and basically told them this and told them that and using what I'm supposed to have said against me. Shame on you. That's okay. I know you didn't mean no harm. You were just trying to set me up. You just trying to be a racist, ignorant mother. That's okay. That's okay. I understand. So I'm going to sit here and I'm going to listen to you because you the adult. And my mama told me when adults are talking, I'm to remain silent. So while an adult's in the room, you an adult. That's right. You an adult. So I'm a little child. I ain't got no rights. I'm a minor. That's right. I'm a minor. So since I'm a minor, because attorneys can only represent minor incompetent people or dead people or corporations. So since you an attorney, I'm the client. I'm a minor because I ain't incompetent. The doctor already said I'm not incompetent. I'm not a baby, not an infant. Well, technically I'm an infant according to the law. But I got my application right here. See, it says age of majority memorialization. So I've already declared my age of majority on my birthday. Okay, so I must still be a minor somehow because I haven't attained assets and control of my securities. So I'm going to sit up here as a minor, and I'm a minor in my own business, and I'm going to let you do all the talking because you like to hear yourself talk. So go out on ahead there, Mr. Attorney. Go on ahead. Oh, I'm not saying no more words. Sorry. I just said another word. Oops, I'm sorry. Oh, I got to put another dollar. Oh, look, another dollar. Oh, God, another dollar. I might as well put my whole wallet in a jar. Okay? That's how I would play it. But again, the games they're playing with other people, they don't play with me. You guys, I know a lot of people won't understand this. They don't put me through the same thing they put the rest of you through. We don't get to play that game. They don't play those reindeer games with me because I don't play well with others. And I tell them that at the very beginning. I don't play well with others. And I'm hated for that, but I can live with that because I ain't got to play well with others. Okay? But I guarantee you, you need to know I don't play well with others. Me and others don't get along. All right, right there, do. All right, that be the case. That be the case. All right, ladies and gentlemen, gentlemen and ladies, ladies and gents, I want all of you to have a good day, a good life, a good night, a good time, and we will see each other the next time. I am going to send this to the young man so that he has it. I'm going to send this to him, and then I'm going to let the rest of you guys get on with your day. I have a meeting to tend to in 5 minutes. Gotta go, gotta go, gotta get out of here already. Gotta go. Goodbye.